The Ancient City. A study on the religion, laws, and institutions of Greece and Rome.
Numa Denis Fustel De Coulanges.
Book 3rd, The City. Chapter 11, The Law.
Among the Greeks and Romans, as among the Hindus, law was at first a part of religion. The ancient codes of the cities were a collection of rites, liturgical directions, and prayers, joined with legislative regulations. The laws concerning property and those concerning succession were scattered about in the midst of rules for sacrifices, for burial, and for the worship of the dead. What remains to us of the oldest laws of Rome, which were called the royal laws, relates as often to the worship as to the relations of civil life. One forbade a guilty woman to approach the altars, another forbade certain dishes to be served in the sacred repasts, a third prescribed what religious ceremony a victorious general ought to perform on re-entering the city. The Code of the 12 Tables, although more recent, still contain minute regulations concerning the religious rites of sepulture. The work of Solon was at the same time a code, a constitution, and a ritual. It regulated the order of sacrifices, and the price of victims, as well as the marriage rites and the worship of the dead. Cicero, in his Laws, traces a plan of legislation which is not entirely imaginary. In the substance as in the form of his code, he imitates the ancient legislators. Now, these are the first laws that he writes.
Let men approach the gods with purity, let the temples of the ancestors and the dwelling of the Lares be kept up, let the priests employ in the sacred repasts only the prescribed kinds of food, let every one offer to the Manes the worship that is due them.
Assuredly the Roman philosopher troubled himself little about the old religion of the Lares and Manes, but he was tracing a code in imitation of the ancient codes, and he believed himself bound to insert rules of worship. At Rome it was a recognized truth that no one could be a good pontiff who did not know the law, and, conversely, that no one could know the law if he did not understand questions relating to religion. The pontiffs were for a long time the only jurisconsults. As there was hardly an act of life which had not some relation to religion, it followed that almost everything was submitted to the decision of these priests, and that they were the only competent judges in an infinite number of cases. All disputes regarding marriage, divorce, and the civil and religious rights of infants, were carried to their tribunal. They were judges in cases of incest as well as of celibacy. As adoption affected religion, it could not take place without the consent of the pontiff. To make a will was to break the order that religion had established for the transmission of property and of the worship. The will, therefore, in the beginning, required to be authorized by the pontiff. As the limits of every man's land were established by religion, whenever two neighbors had a dispute about boundaries, they had to plead before the priests called
Fratres Arvales.
Arval brethren, brothers of the fields.
This explains why the same men were pontiffs and jurists, law and religion were but one. At Athens the archon and the king had very nearly the same judicial functions as the Roman pontiff. The origin of ancient laws appears clearly. No man invented them. Solon, Lycurgus, Minos, Numa, might have reduced the laws of their cities to writing, but they could not have made them. If we understand by legislator a man who creates a code by the power of his genius, and who imposes it upon other men, this legislator never existed among the ancients. Nor did ancient law originate with the votes of the people. The idea that a certain number of votes might make a law did not appear in the cities till very late, and only after 2 revolutions had transformed them. Up to that time laws had appeared to men as something ancient, immutable, and venerable. As old as the city itself, the founder had established them at the same time that he established the hearth.
Moresque viris et moenia ponit.
He sets up laws and city walls for men.
He instituted them at the same time that he instituted the religion. Still it could not be said that he had prepared them himself. Who, then, was the true author of them? When we spoke above of the organization of the family, and of the Greek and Roman laws which regulated property, succession, wills, and adoption, we observed how exactly these laws corresponded to the beliefs of ancient generations. If we compare these laws with natural equity, we often find them opposed to it, and we can easily see that it was not in the notion of absolute right and in the sentiment of justice, that they were sought for. But place these laws by the side of the worship of the dead and of the sacred fire, compare them with the rules of this primitive religion, and they appear in perfect accord with all this. Man did not need to study his conscience and say,
"This is just, this is unjust."
Ancient law was not produced in this way. But man believed that the sacred hearth, in virtue of the religious law, passed from father to son. From this it followed that the house was hereditary property. The man who had buried his father in his field believed that the spirit of the dead one took possession of this field forever, and required a perpetual worship of his posterity. As a result of this, the field, the domain of the dead, and place of sacrifice, became the inalienable property of a family. Religion said,
"The son continues the worship, not the daughter."
And the law said, with the religion,
"The son inherits, the daughter does not inherit, the nephew by the males inherits, but not the nephew on the female side."
This was the manner in which the laws were made. They presented themselves without being sought. They were the direct and necessary consequence of the belief. They were religion itself applied to the relations of men among themselves. The ancients said their laws came from the gods. The Cretans attributed their laws, not to Minos, but to Jupiter. The Lacedaemonians believed that their legislator was not Lycurgus, but Apollo. The Romans believed that Numa wrote under the dictation of one of the most powerful divinities of ancient Italy, the goddess Egeria. The Etruscans had received their laws from the god Tejas. There is truth in all these traditions. The veritable legislator among the ancients was not a man, but the religious belief which men entertained. The laws long remained sacred. Even at the time when it was admitted that the will of a man or the votes of a people might make a law, it was still necessary that religion should be consulted, and at least that its consent should be obtained. At Rome it was not believed that a unanimous vote was sufficient to make a law binding. The decision of the people required to be ratified by the pontiffs, and the augurs were required to attest that the gods were favorable to the proposed law. One day, when the tribunes of the people wished to have a law adopted by the assembly of the tribes, a patrician said to them,
"What right have you to make a new law, or to touch existing laws? You, who have not the auspices, you, who, in your assemblies, perform no religious acts, what have you in common with religion and sacred things, among which must be reckoned the laws?"
From this we can understand the respect and attachment which the ancients long had for their laws. In them they saw no human work, but one whose origin was holy. It was no vain word when Plato said,
"To obey the laws is to obey the gods."
He does no more than to express the Greek idea, when, in Crito, he exhibits Socrates giving his life because the laws demanded it of him. Before Socrates, there was written upon the rock of Thermopylae,
"Passerby, go and tell Sparta that we lie here in obedience to its laws."
The law among the ancients was always holy, and in the time of royalty it was the queen of the kings. In the time of the republic it was the queen of the people. To disobey it was sacrilege. In principle the laws were immutable, since they were divine. It is worthy of remark that they were never abrogated. Men could indeed make new ones, but old ones still remained however they might conflict with the new ones. The code of Draco was not abolished by that of Solon, nor were the royal laws by those of the 12 tables. The stone on which the laws were engraved was inviolable, or, at most, the least scrupulous only thought themselves permitted to turn it round. This principle was the great cause of the confusion which is observable among ancient laws. Contradictory laws and those of different epochs were found together, and all claimed respect. In an oration of Isaeus we find two men contesting an inheritance, each quotes a law in his favor. The two laws are absolute contraries, and are equally sacred. In the same manner the Code of Manu preserves the ancient law which establishes primogeniture, and has another by the side of it which enjoins an equal division among the brothers. The ancient law never gave any reasons. Why should it? It was not bound to give them, it existed because the gods had made it. It was not discussed, it was imposed, it was a work of authority, men obeyed it because they had faith in it. During long generations the laws were not written, they were transmitted from father to son, with the creed and the formula of prayer. They were a sacred tradition, which was perpetuated around the family hearth, or the hearth of the city. The day on which men began to commit them to writing, they consigned them to the sacred books, to the rituals, among prayers and ceremonies. Varro cites an ancient law of the city of Tusculum, and adds that he read it in the sacred books of that city. Dionysius of Halicarnassus, who had consulted the original documents, says that before the time of the Decemvirs all the written laws at Rome were to be found in the books of the priests. Later the laws were removed from the rituals, and were written by themselves, but the custom of depositing them in a temple continued, and priests had the care of them. Written or unwritten, these laws were always formulated into very brief sentences, which may be compared in form to the verses of Leviticus, or the slokas of the Book of Manu. It is quite probable, even, that the laws were rhythmical. According to Aristotle, before the laws were written, they were sung. Traces of this custom have remained in language. The Romans called the laws
Carmina.
verses, the Greeks said
Nomoi.
songs. These ancient verses were invariable texts. To change a letter of them, to displace a word, to alter the rhythm, was to destroy the law itself, by destroying the sacred form under which it was revealed to man. The law was like prayer, which was agreeable to the divinity only on condition that it was recited correctly, and which became impious if a single word in it was changed. In primitive law, the exterior, the letter, is everything. There is no need of seeking the sense or spirit of it. The value of the law is not in the moral principle that it contains, but in the words that make up the formula. Its force is in the sacred words that compose it. Among the ancients, and especially at Rome, the idea of law was inseparably connected with certain sacramental words. If, for example, it was a question of contract, one was expected to say,
Da rispondes.
Do you promise that it should be given?
and the other was expected to reply,
Spondeo.
I promise.
If these words were not pronounced, there was no contract. In vain the creditor came to demand payment of the debt, the debtor owed nothing, for what placed a man under obligation in this ancient law was not conscience, or the sentiment of justice, it was the sacred formula. When this formula was pronounced between two men, it established between them a legal obligation. Where there was no formula, the obligation did not exist. The strange forms of ancient Roman legal procedure would not surprise us if we but recollected that ancient law was a religion, a sacred text, and justice a collection of rights. The plaintiff pursues with the law.
Agit lege.
He pursues with the law.
By the text of the law he seizes his adversary, but let him be on his guard. To have the law on his side, he must know its terms, and pronounce them exactly. If he speaks one word for another, the law exists no longer for him, and cannot defend him. Gaius gives an account of a man whose vines had been cut by his neighbor. The fact was settled, he pronounced the law. But the law said trees, he pronounced vines, and lost his case. Repeating the law was not sufficient. There was also needed an accompaniment of exterior signs, which were, so to say, the rites of this religious ceremony called a contract or a case in law. For this reason at every sale the little piece of copper and the balance were employed. To buy an article, it was necessary to touch it with the hand.
Mancipatio.
Transfer, manus plus carpio, literally, a taking with the hand.
And if there was a dispute about a piece of property, there was a feigned combat.
Manum concertio.
Joining of the hands.
Hence were derived the forms of liberation, those of emancipation, those of a legal action, and all the pantomime of legal procedure. As law was a part of religion, it participated in the mysterious character of all this religion of the cities. The legal formulas, like those of religion, were kept secret. They were concealed from the stranger, and even from the plebeian. This was not because the patricians had calculated that they should possess a great power in the exclusive knowledge of the law, but because the law, by its origin and nature, long appeared to be a mystery, to which one could be initiated only after having first been initiated into the national worship and the domestic worship. The religious origin of ancient law also explains to us one of the principal characteristics of this law. Religion was purely civil, that is to say, peculiar to each city. There could flow from it, therefore, only a civil law. But it is necessary to distinguish the sense which this word had among the ancients. When they said that the law was civil,
Ius civile.
Civil law.
Νόμοι πολιτικοί.
Political laws.
they did not understand simply that every city had its code, as in our day every state has a code. They meant that their laws had no force or power, except between the members of the same city. To live in a city did not make one subject to its laws and place him under their protection, one had to be a citizen. The law did not exist for the slave, no more did it exist for the stranger. We shall see, further along, that the stranger domiciled in a city could be neither a proprietor there, nor an heir, nor a testator, he could not make a contract of any sort, or appear before the ordinary tribunals of the citizens. At Athens, if he happened to be the creditor of a citizen, he could not sue him in the courts for the payment of the debt, as the law recognized no contract as valid for him. These provisions of ancient law were perfectly logical. Law was not born of the idea of justice, but of religion, and was not conceived as going beyond it. In order that there should be a legal relation between two men, it was necessary that there should already exist a religious relation, that is to say, that they should worship at the same hearth and have the same sacrifices. When this religious community did not exist, it did not seem that there could be any legal relation. Now, neither the stranger or the slave had any part in the religion of the city. A foreigner and a citizen might live side by side during long years, without one's thinking of the possibility of a legal relation being established between them. Law was nothing more than one phase of religion. Where there was no common religion, there was no common law.